Good afternoon, please. From today's session focuses on the Code on Social Security 2020. I am Dhanasvi Misri from the advisory team at Karma Global, and joining me today are Mr. Pratik Vaidya, our Managing Director and Chief Vision Officer, and Ms. Sadaf Khan, our Head of Legal and Advisory. To begin today's session, Sadaf will talk you through an overview of the Social Security Code 2020. Over to you, Sadaf.
Thank you so much, Dhanasvi. Am I audible to everyone? All right, so we'll carry on. First of all, good afternoon, everyone, and welcome back to our part B of a series. So let's take you through an in-depth understanding of the code on Social Security. So first, let's understand why the Social Security was written. So, first of all, the challenge that was faced earlier before this act was written is that there were multiple acts. So, initially, this act was this code codifies nine central legislations. So, there were multiple legislations in this matter. There were multiple definitions in each of these legislation. For example, the definition of wages, the definition of employees, the basic enumerations, and different things that were given to them, the conditions and everything were different. The definition itself for the employer part also was different. So because of this fragmentization as well as the multiple definitions, there were a lot of discrepancies. Then there were limited digital delivery. So first of all, not every single act under this these acts that were considered in this code had their own portal to log in and to gain the benefit. So, and one more important part was with regards to the inadequate coverage of the unorganized and the gig workers. So, what were gig workers? The entire concept of gig workers was not initially covered in this. They were not even recognized as a person who would get any social benefit or social security benefit. So, the solution for this problem was that this new code on social security was consolidated into one, and it came into force on 21st November. So now nine of the acts are into the single framework. It harmonizes the core concepts of that universal definition of employees and wages as well as the employers. So it recognizes the new work arrangements that are given for them, the new social benefits that are provided to them. Like for example, the gig workers will now be considered under ESIC as well as EPF. And it also facilitates portable social security, which is like they can easily log in on their phones to understand what exactly benefits or how much exactly contribution is currently in their accounts and all. So specifically for gig workers and any other employees that were not considered before. Then now we understand what this social security code has and what exactly it covers. Like for example, the first act, the Employee Compensation Act of 1923. Earlier there was an entire different act. Now it is covered under this code under chapter 7 of the Social Security Code. So then the Employee State Insurance Act of 1948. So this act is now covered under chapter 4. Accordingly, the Employees Provident Fund and Miscellaneous Provisions Act, which is the EPF and MP Act, specifically relating to the EPF and pension provisions and EDLI provisions, it is covered under Chapter 3. Then we have the fourth act, which was covered in this. It is the Employees Exchange Compulsory Notification of Vacancies Act of 1959. Though a specific chapter was not given for this act, it has been integrated in the main framework of this entire code. Then we have the Maternity Benefit Act of 1961, which is now considered in Chapter 6, whereas the Payment of Gratuity Act of 1972 is under Chapter 5, and the Cine Workers Welfare Fund Act 1981, uh, same like the Employees Exchange, has been integrated into the main framework, and no specific chapter itself has been given for the act itself. Then we have the BOCW, which is the Building and Other Construction Workers Welfare Cess Act of 1996, which is under Chapter 8. So this is very important to note. BOCW Act and BOC Welfare Cess Act are two different acts. The welfare cess is with regards to the contributions as well that's given here, and the BOCW is with regards to the working conditions, which is already covered in the OSH Act. So that has been taken under OSH, and the cess part, the cess Act itself, has been covered under the Social Security Code. Then we have the Ninth Act, which is the Unorganized Workers Social Security Act of 2008. So this is very important to note. Earlier, unorganized workers were already covered in this act, and now it's under Chapter 9 and also recognizes gig and platform workers. So this is just more like a unified legislative platform for multiple social security schemes, enabling them portability, convergence, and easy accessibility to maintain the registers and digital delivery here. So let's understand the repel and saving part here. So in plain language, what has been repelled from 21st November 2025? So the notification that came forth specified clearly in section 164 that Employee Compensation Act, the State Employee State Insurance Act, the Employment Exchange Act, Maternity Benefit Act, Payment of Gratuity Act, Senior Workers Welfare Fund Act, BOCW Welfare Cess Act, and the Unorganized Workers Social Security Act has been repealed. It is very important to note that item number 1 till item number 9 has been repealed except the item number 3. So the item number 3, which is section 164.13, specifies the repealing of Employees Provident Fund and Miscellaneous Provisions Act. So as per the notification, that part was not enforced, which means that EPF Act still remains. So now a lot of you might have this question with regards that there was an earlier notification in 2023 wherein the EPFO and the central government mentioned that this specific item number was already being enforced at in 2003. So with regards to this, let me clarify on that we align with the industry experts, with the Ministry of Labor with regards to this exclusion, and accordingly the notification itself clarifies that only the pension part with regards to the EPF is repelled. Whereas with regards to the provident fund part of the EPFO is still in force. So right now, as it is ESIC, EPF and everything, the cap limit still is the same. No new, accordingly, until unless no new notification or guidelines has been released by the government, till then the cap limit of 21,000, 15,000 will still remain. Whereas EPF in whole will still remain. Pension part, yes, that is repaired, but EPF in whole still remains. So let's understand what the saving part means. So except these parts, what does the saving clause of section 164.2 of the COSS provides? So notwithstanding anything written here under, all rules, regulations, schemes, notifications, order continue to stay in force so far as it is not inconsistent with this code, then all the rights, privileges, obligation, liabilities will continue to remain the same. The investigation, legal proceeding, remedies, which shall also remain unaffected and may continue until and unless the COSS rules have not been enforced. So once the rules are enforced, we'll get a more clarity on how this entire part with regards to investigations, the contributions, the capping limit, and everything will change. But until then, whatever with regards to employee state insurance and everything else shall remain the same. Now, let's give you an understanding more on with examples on the repel and saving part. So, before 21st November to 2025, so ESI covered employees suffering employment injury, medical treatment, cash benefits, and all were provided under the Act, and a claim for dependent benefit used to be pending. So now here, I like to clarify on this part that so anybody who was covered under ESI and if they had any injury, definitely that will be coverable under ESI. Whereas with regards to anybody having a monthly salary of beyond 21,000 were given the compensation through the Employee Compensation Act. However, there was a drawback back then, which regards to the Schedule 2, which clarified that only employees under these employments would be considered under the Employment Compensation Act. Remaining every other industry will not be a part of it, and this act won't be applicable to them. Now, with this code, every single person, whoever falls under the definition of employees, will be covered. There is no schedule 2 in this specific part, and anybody and everybody, whoever is considered as an employee in any establishment, will be considered here. So let's understand then, like from 21st November, how it goes on. That is, as I already mentioned, they'll be covered. Then ESI Act specifically is repealed, and Chapter 4 came into force. And now the definition of wages, the family, the dependent part, all of it changes. So one of the interesting things where this code has also enforced is with regards to the definition or the term family when it comes on adding them in ESIC dependence part. So earlier, the dependent list was comparatively quite lesser. Now they also include in-laws, they also include disabled adult son, and accordingly, so it's a more wider definition. So the pending claims continues on the ESIC scheme now will be a part of the COSS. Then the employees' right, ESI obligations, and the ongoing proceedings will be preserved under Section 164.2, which is the saving part of it. Then we have the scheme which will operate seamlessly under the new framework. So, as I've clarified, that repeal does not extinguish the schemes or the rights and the proceedings which are already present, but in fact, it will stay the same and until and unless a new rules or more clarity on understanding is brought on by new guidelines by the government on this thing. So now I would like to invite Mr. Prateeks to provide an in-depth knowledge and understanding about the changes brought on by the Social Security Code. So over to you, Prateek.
Hi, good morning, everyone, or good afternoon, everyone. And I understand that today is Wednesday, and we just had over 500. Unlike last Friday, where more than 1,000 people had attended, but 500 also plus is a very overwhelming figure, despite Wednesday and midweek we kept. Thanks to that. I mean, in fact, she shared what I'm going to share in all the slides. So, a unified framework, how the rest of the session flows, which I'll tell you. Like from here onward, we're going to walk inside the building of this code and social security. Slide 1 to 5, which Sada was explaining, was more of a satellite view, why the code name and what got merged and all. Importantly and interestingly, if I share you the results of the earlier poll, which we had, you know, uh, can you share the results of the poll of which of the act is repealed? 57% of the people said that, no, the earlier one. 57% people said that PF Act is not also repealed. And that's important for you to note that PF and NP Act remains same. I'll explain in the further slides. So PF and NP Act still remains your wages, your the calculation of PF, everything remains same. It's still not touched. So that's the biggest clarity I just wanted to give you guys. So that's where it is. Uh, all right. So can we go to so okay, fine. So what I'm trying to say here is the slide till the end. What I will clear is we'll follow a clear path. First, the common language, what is wage, family dependence, and all, which I've already clarified in part one when we were doing a code on wages. But I'll just reiterate that bit again for the people who may have missed part one. Second classic pillars of PF, ESIC, gratuity, maternity, employees combination we'll do. Third, the new pillars, which are like organized workers, gig and platform workers. I'll touch base on those as well. And then finally, I'll also touch base on inspection limitations and what are the practical aspects and plan for the employers. So let's go floor by floor, section and not section by section here. All right. So first is, this slide is put up is unified wage definition under code and social security. So this is the first common brick across all the codes and the new definition of wages, unlike with the scattered definition of wages which is there. So in simple language, core wages is what? It is basic plus DA plus retaining allowance, if any. That's very important. Then comes your exclusion part, your bonus, your HRA, your overtime, commission, employers' PF contribution, gratuity, and a list of specified allowances and perquisites between A to I. That is important, which I had explained earlier, but that is where it is coming under exclusion. So for the social security, this definition is the backbone. It's very, very critical. It is intended to use for ESI, gratuity, maternity, EC, that is employer compensation, BSW welfare, many scheme calculation linked to the code. And eventually PF Act also, when the PF comes part of the code on social security when it is further notified. So in your payroll system today, what you need to do is different wage definition for every law, and this is nuts to just clean that up because you may be having like calculation gratuity in something else, that calculation ESS is something else, calculation PF something else. You need to just ensure that now everything will be sacrosanct and it's a common brick which you say. That's what I do. Slide 8. Sorry, I missed to uh, put off my phone. All right. Can we just go to the next slide, please? Okay. So 50% rule concept, what it is, as I mentioned in the part one as well, our drafters or the people who had written the code or the lawmakers, they all knew that how we love our salary structure. Recently, also, I told me someone was telling me, what if I keep 40% as basic and 60% as allowance? How do I calculate? I clearly told one of the groups that do not get into all shortcuts now. The lawmakers, they know it very clearly, so they introduce a simple but powerful 50% cap on exclusions. So, what is the game about? First of all, add up everything paid in cash, salary plus all allowances, and that's your total remuneration. Then add up all items sitting in the exclusion list, and that is, mind you, A to I, except that part C, which is PF employer contribution, will not take an exclusion list. Why? I had explained earlier also, just repeating again, because the employer contribution paid to the fund. It's not from employer to employee. So what is paid from employer to employee, that you need to consider in A to I. Then, if exclusions, this A to I, except the employer contribution which you remove, exclusion, if there's more than 50%, the excess must be pulled back to the wages. So that's the clear thing. So in other words, you cannot have 80% as the package into allowances, and then social security is about 20%. You cannot have that anymore now. Code will correct it itself, and you need to apply that formulas and just structure your payroll accordingly. That's what I would like to tell you that. Can we have the next slide, please? So let me just give you the example which I had covered it earlier. And mind you, please go to the homepage of karmamgmd.com, www.karmamgmd.com. In the homepage, you'll find all the resource materials. I've seen some couple of questions, people asking that I did not attend part one, missed out. Can I have that slides? So in the part one, all the FAQs and PPTs already uploaded. And after this today's presentation, we will also upload the part two as well. All right. So take this numeric example. What does it say? Total monthly payout is the remuneration is 60,000, which is R. Basic plus D is 20,000, if you see 18 plus 2, right? And then all exclusions are there: HRA, special allowance, conveyance, that all add up to 40,000. So 50% of the 60,000 is 30,000, right? So the exclusions are 40,000, which means we are 10,000 over the cap. That's where it is, right? So that the 10,000 has to be treated as wages. It has to come about for social security purposes, whatever PF, ESI, all those things. That 30,000 is what you should be using as base, a wage base for ESSC, gratuity, maternity need, all those things, subject to respective ceilings and subject to schemes definition as and when they tell. But bigger picture is that now, based on the definition, your formulas should be set in a way it automatically corrects it and just puts it into the wages, and you calculate. It may also happen that you have situation where overtimes are there, and in overtime you may have to have sometimes it may be dynamic in nature to add all those things in wages if there are more overtimes, and if the 50% goes more, the exclusion list goes more than what the overall remuneration is. But that's the hard fact, and you need to recalibrate your formulas, your Excel, your software programs, HRMS, whatever you're using according to this new. All right. So let's jump into the next slide, please. So PF EPS EDLI, as Sadaf clarified, the item number three is not yet repealed. So where does it sit now? So under the so now the big question here is everyone is worrying about PF. I know that under the new code framework, the PF chapter, as on date, EPF and Miscellaneous Provision Act, the existing PF, EPS, and EDS schemes continue. Only section of some pension things is repealed, and it is part of the Code on Social Security based on 2023 notification. But the formal repeal of PF Act has not been notified. So that is where it is. So practically, PF wages are still governed by the EPF Act and the Supreme Court line of basic wages. We had, uniform and the whole definition which was there as wages, right? Uniformly and ordinarily and necessarily. Contribution ceilings continue to a 15,000. Higher wage options, EPS treatment, all of that continues as such. Including international workers, the full basic wages just continues as it is. Nothing changes. So the code is like a new container ready for PF in the future. So we have the container, and whenever government announces and actually switches PF into the container by notification scheme changes, you run the PF as it is with the old framework. But just keep an eye on the how code provisions around enforcement and limitations might be adopted later. That's the whole thing which I want to do. And also, you need to ensure that now is the time to actually recalibrate your wages very close to what the code on wages is all about, or the wage definition under various codes are all about. Yeah. Next, please. So let me just give you a basic, comparison here. One side is the PF, the whole wage, which I told that's not yet repealed. Other side is all other eight acts which are subsumed under repeal. How do you have to look at it? So PF wages today, as I told, defined by PF Act and case laws, primary basic plus certain allowances, which is there already. You're doing it. Used for only PF pension in EDLI. That's what it is. With a wage ceiling of 15,000 unless you opt for higher coverage. It is optional. That's what the PF is. And Social Security under the code, basic plus DA plus retaining allowance, we saw that as a total remuneration as a way up a part of the whole core wages. And minus exclusions with the 50% of the cap adjustment, we already clarified in the example. Used for ESIC, gratuity, maternity, employee compensation, BOCW welfare, and various schemes. The key message is that keep PF wage and code wage as two separate calculations as of now. Coming back to ESIC, we already, we will just speak about ESIC the next slide. Can you just go to the next slide, please? ESIC, we already had certain notifications, like in 20th November 2025, the last week the notification came. They just mentioned some of the family and benefits to extended to dependent and family. So ESIC will keep on coming with such notification. Until that, ESIC wages will be same as earlier ESI Act 2048, but formally this ESIC is already under this Code on Social Security. So just wanted to clarify here. So there are two things happening here now. One is ESIC is moved to a new Code on Social Security umbrella. So future schemes and definition will be aligned with the code. They already given the notification here. Second, the immediate change is already visible on as on 20th November. If you see around the family and dependents, and code and ESIC circulars broaden who can be treated as a family dependent, like example, widowers, grandparents. I think Sada's already clarified that. In case of women employee, even father-in-law and mother-in-law also are covered if they're gender dependent within the income limits and they are actually financially dependent on the female employee. So that's where it is. So what about wages? For the moment, contribution continues on existing ESA wage as a tool until the slab specific until ESI Corporation specifically notifies new wage rules under the code. That's very important. So the practical advice from our end is start using the unified wage definition for design and planning in the near future. maybe next 2 3 months down the line. Keep being updated on whatever the notifications are coming through you. Of course, Karma will always be there to notify you if you're subscribed to us. But in day-to-day operations, follow existing ESA contribution rules and ceilings is up to 21,000. And plus, and the new family and dependent coverage wherever notified. So that's very important. So why are we stressing so much on PF, especially family and dependents, as per new code? And why did they come up with the 20th November notification? That's clearly to make sure that you understand that. It directly decides who gets benefits. If you see, when something goes wrong, who can get dependent benefit, who can claim medical benefit, who is eligible when an insured person passes away or becomes permanently disabled. So that is very just extending what it is. So under the pre-code regime, if you know ESI Act, in-laws and extended family members were usually outside the frame, including uh, disabled persons, and adult disabled persons also were out of the frame. But now everyone is inside under the new framework. If they are financial dependent and more meet that income criteria which is there, they will sit and come inside this. All they are covered under this. So this is very much Indian reality. If you see, many of the households they are part of joint families, and even if the widower is there or female separated, they want to actually uh, take care of the in-laws. They can now do so. So HR needs to actively help employees to update their dependent details in nomination as on today or as on 20th November itself. Otherwise, you'll see disputes and delayed benefits later. So that's very important if they want to have. Yeah. So that's where I would like to say that's as far as ESS is concerned. Let's get into next part is about gratuity, which I'll take you through. So old Payment and Gratuity Act is definitely repealed when the new gratuity chapter of the code comes in, but the core is still retained, like 15 days formula, which is there, 15 days wages per completed year of service, and then continuous year of service as defined is also remains the same. At least 240 days of continuous year service makes a year, right? To continue days of service, or 240 days makes a year. So that is there, and also with service beyond 6 months, it's rounded up subject to the overall prescribed ceiling, which is right now 20 lakhs, right? As per income tax now. So changes in the wage base, if you go to see. That's the only big change. Rest gratuity remains same, right? Gratuity wages now follow the code wage definition as the 50% rule. So some of people may have a practical question. I'm just looking at some questions here, and I would want my team to just respond to that. Some may have a practical question. What if an employee is serving a notice period? Say an employee has resigned and served a notice period on 1st November, and his last date of working is 30th November. So what happens to that? So remember one thing: if he's serving already a notice period and the last day of the work after the court commencement after 21st November ends at 30th November, even for gratuity, if you see as per the law, earlier Payment of Gratuity Act and now a part of Code and Social Security, is on the last working day, whatever the wages are there, and not the date of resignation. So technically, the code chapter applies. All services rights accrued under the old act are protected. So the safest approach is to compute gratuity under the code framework and ensure that the amount is not less than the what old act would have given. If there's a difference, you pay the higher amount. And that keeps you aligned with both the letter of spirit and the beneficial of law. That is our suggestion, which is very, very important. I hope you got this whole scenario of gratuity. One more important aspect of gratuity, which I'll talk in the next slide, is about fixed term employees. So very, very progressive provision that survives in the code is gratuity for fixed term employees. Again, like we were very creative in uh, doing the wages part, we were always creative, companies were very creative in saying that, okay, fine, you go on FTC 1 year, 2 year, give a gap, and then they used to relinquish the right of a gratuity if he really works in FTC period for 5 to 6 years. So now you cannot do that because that's where the new provision is there. So if a fixed term employee completes 1 year of continuous service, they become eligible for gratuity on a pro rata basis, even if they do not reach 5 years. So take a 2 year fixed term contract, for example. The employee actually serves 14 months. Wage is say 40,000. Since more than 1 year of continuous service is there, it's completed, gratuity is payable on that 15 divided by 26 formula on the code of wages. If an employee or on the fixed term contract basis, if he finishes 9 months of his service and not even that first calendar year, still he will be eligible for 1 year of gratuity. Why? Because the 1 year of continuous service under the Gratuity Act earlier, which is also continuing now as per repellent savings, is 240 days. If an employee is worked for 240 days, it will consider it as a year. So remember that even if you have 9 months contract, it will be considered as 1 year, and you need to pay gratuity towards it if he is under fixed term contract. So the message for HR is simple. Fixed term is no longer a quiet way to avoid long service benefits. You have to plan gratuity costs in F2C as well. It will come and add to your actual value in the liability side of your gratuity. And that's what you need to really plan it well. If you have FTCs on ground as of today or as of 21st November 2025. Now let's take it to the next thing is about maternity benefit. No major change at all. Maternity benefit is sits under Social Security Code and as well, but the core remains the same. We know already it is 26 paid day a leave for up to two serving children, 12 beyond that. Then plus coverage is for adoptive and commissioning mothers also with some conditions. So that is continuing as it is when which the earlier Maternity Benefit Act also provided. A very common scenario I'll tell you. Say a woman joins and is already pregnant, okay, does not disclose at the time of joining and informs HR after 3 months by the time she's already completed more than 80 days of work. I don't know how many of you have this situation, but I've seen some of the organizations having this situation if a female employee has done this. Can the employer say, you did not tell us during the interview, so you're not entitled to maternity benefit? And I don't know how many of the employers have said this also. Let me tell you one thing. The answer is no, you cannot do that. The legal test is whether she has worked the at least 80 days in 12 months or not before the expected date of delivery. That's the legal test. And whether she is otherwise covered by ESI or code. So if it's not covered by ESIC, she'll work 80 days, irrespective of she is declared or not declared, you need to pay maternity benefit. So that's very important to you need to know. So there's no requirement that she must have declared pregnancy at hiring. Any offer letter or policy laws that tries to take away this right will not stand in law. And that's very important. So HR ensure that you should be very clear. We can have medical fitness checks, but we cannot contract out of maternity benefit. You may want to get into a medical fitness as part of things, and if you realize that based on the medical fitness before the employee joining, whatever she said or he said is not true, you can definitely deny. But after a person joins and works for 80 days and you're not found out, you need to give the maternity benefit. So that's very important for you to see this. I'm very happy that now you know that FTC is on a pro rata basis for 1 year and not on the contract renewal. So thank you very much. I just shared that Paul night. So that's nice. That's very important. So let's go into next one. I hope I'm going to a right space and I'm not rushing through. So if I can just get one acknowledgement, I'm sure that I'm just going to the right space. That's fine. So I'll just go ahead with that. Thank you. Let's take into employee compensation under Code on Social Security. So who is covered now? Sadaf has already clarified that earlier it was just a schedule, and one of the schedules which is covering certain section of employees only were covered. Earlier known as, first of all, it was earlier known as Workmen Compensation Act. If you remember 1923, which is now Employee Compensation Act, and that's now everything is moved into one chapter of this code. It covers death, it covers permanent disablement, it covers temporary disablement, and certain occupational diseases that arise out and in course of employment. It covers all those. And whether employee is not covered under ESIC, employment injury benefits. Very important to note that if the employee is not covered in ESIC, those employees will be covered under EC Act or the code, the EC chapter under Code on Social Security. So important shift is who can be covered. So code's definition of of the employee is broader than the old workman focus. So a wider range of white collar employees, including maybe some of the directors who are already on the payroll, right? And in some case, whole-time directors and the salary with an employment contract, if they have, can come within the scope of this, and depending upon whatever the facts are there. So that's very, very important to know. Every employee is covered. So your first fitter after an accident should be, is this a person under ESI or not for employment injury? If yes, then follow ESI. If not, then they are they employed in the substance and the ESI, the Employee Combination Act or the provisions of that under the Code on Social Security Act will be executed and will be provided to them. All the benefits under EC Act, even if he's a director, manager, supervisor, whatever, on the payroll, receiving salary and being covered under the definition of employee will have the benefit under EC. That's what I wanted to clarify this very clearly on this. I would urge my team to, help employees. I mean, a lot of questions are there, and help them to respond to that. And one more thing, I just want to tell you: after my presentation, we will keep this whole section open for as much as questions to be answered. So do not worry about that. That once my presentation is over, we will see some few questions, and we'll be just close it. We'll continue to respond to the question in another half an hour or so. All right. Uh, so that's what it is. So let's see how this pieces fit together when I talked about all the major part about PF, ESIC, and others, which is there. So PF pension EDLI, again, I'm telling you, they have their own chapter, but still lean on PF Act and scheme still is formally shifted. So do not change anything that PF, EPS, EDLI. That's very important. ESS sits now in a dedicated chapter under the code, and that's very, very clear on that. ESIC corporation, whenever they notify you time to time, including the change in wages, including the ceiling limit and all, they will inform time to time, and you need to implement it time to time, like how they've done on 20th November onwards. So till that time, ESIC would be the same wages which they had earlier done. Gratuity, maternity, employer compensation have their own chapters. I need to ensure that you follow those very, very clearly. Social Security on BOCW, Building and Other Construction, it's financed by CES and has another chapter. So that's very important. And lastly, I'll be talking about Social Security about BOCW as well as unorganized workers and gig platform workers. What is it? All these are resting on very common definition. If you see, what are the common definitions? Wage, employee, family dependents, and those common procedural rules on inspection limitation. So this is how all the pieces are fit together. So we need to design a compliance cockpit, and it should be a mirror of what you're trying to do. And we can also help you in that, creating the whole compliance cockpit for common and all the aspects of social security. Let's go to the next place about unorganized workers. So whatever we spoke about was for organized sector, right? PF, ESI, PF, ESI, and all other benefits and the maternity benefit and all. So now let us step. out of the organized sector to the unorganized. So we already had an act called Unorganized Social Security Act. Registration was fragmented actually. One board here and there, another scheme there, and huge number of workers never got registered anywhere. There are a lot of boards actually for under this particular act which was there. So now under the Social Security Code, what government is trying to do is that they have single registration for unorganized sector. Something like e-shram type 2 model may come up, linked with Aadhaar and bank account, like how you have in PF in ESIC, something similar to that. And then use that ID to plug into multiple schemes, which our government will keep on announcing and will cover life, will cover accident, will cover health, maternity, old age support, and so on and so forth. Very much similarly mimicking all benefits which a regular employee gets, an organized employee gets, organized sector employee gets. So similarly mimicking that particular benefits to the unorganized sector as well. So earlier it was like go and chase each scheme separately. Those organized workers, they had to do this. Now it is moving towards get on the register, national register once, and scheme can ride on top of that. So that's very, very good, inclusive, and one single platform approach what the government has done. But we are still in transition. It's still not clear how the direction will be going. But the framework is already there, and we'll have to see the notification which come from the government, what they have to do with the unorganized sector. So so we already spoken on organized sector. Let's talk about what are gig and platform workers here. So this slide is like three sets of people side by side. If you go to see here, one is like unorganized sector, which I already spoken. Home-based workers are there, like self-employed people are there, casual workers are there, small shops are there, informal sector, which are normally there or not covered under PF and ESSC. Those are unorganized workers per se. Gig workers, the people working outside this traditional employer-employer relationship, like you have your Ola, Uber, or kind of people who are the gig workers, right? They have their own maybe cars and they fly and they are on the platform of the aggregator or they are working on those. Even a lot of companies, they have software tech guys as gig workers as well. They give them project base and the guy he produces his invoice and they get paid on project basis. So they all form part of gig workers. Then you have something like platform workers. So gig workers who get through an online platform or an app, something like Swiggy, Zomato, they all platform workers. That's what I would like to clarify the basic minute difference between gig and platform workers. So for unorganized workers, the model is mainly government funded or cess funded schemes. That's very, very important for you need to know. Run by welfare boards. So yeah, I just repeated the unorganized workers, which is the left side. The model is government funded or this cess funded schemes. We all various sense which is run by welfare boards. For gig and platform workers, the code has creating a separate social security fund where the aggregators have to contribute along with the government. None of the amount would be deducted from the gig and platform workers, unlike what you have in an organized sector of PF and ESSE, where equal contribution is there, or what is the contribution? There is some contribution from the employee side as well. But here for the gig and platform workers, everything is through the aggregators fund and along with the government fund. So that is what it is. The aim is actually these workers get some safety net, even if their relationship is not permanent in any company and employment contract. So that is where the government wants to actually bring gig and platform workers along with unorganized workers in that chapter on code and social security. Let's dive into more on this gig workers, platform workers, because that's a new thing. And I would want to elaborate that is more on that. So first of all, let's understand. Again, I reiterate what exactly the vocabulary is so that no confusion is there in future. So gig worker, it's someone who earns from work outside of the regular employer-employer relationship setup. It may be an hourly basis. It may be just one task, one project, as I told you the example of like a software tech guy and something like that. The consultants who are there, they have auditors who are also part of gig worker. They all come being part of gig worker and they invoice it and they get paid of that. A platform worker, on the other hand, is like a gig worker but get work through an online platform. So that's where it is. So your all your rider hailing apps like your Uber, Rapido, and Ola, they all may be covered under that. Then food delivery apps which are there, Swiggy, Zomato, and all that. Logistics are there, home services, and so on. They all are part of your online platform, and that becomes a platform worker. An aggregator is a platform company. So your actual Swiggy, actual Zomato, all these platform companies that connects the customer to the worker. So we naturally know what I'm talking about. And this under this code, aggregator's responsibility is that he has a statutory duty on him to contribute towards the social security fund for this gig and platform workers. Earlier, it was not there. Now it is mandatory for all these aggregators to ensure that benefits is given to the platform workers, which was not there in this. So once we are clear about this three term, the contribution scheme logic becomes very easier to read. I hope you just got this information. Let me tell you how the code is set up on this fund. Let's because a lot of companies and some of my clients as well, they're also like aggregators here. So colon social security, how it is a security fund for gig and platform workers is set up. Money flows into this fund in three directions, from three directions. First of all, contributions from aggregators, as told you. And there may be some certain grants from the central and state governments, depending upon the rules and schemes notified under the Code on Social Security from time to time. And other prescribed sources may be there as part of this fund. And out of the funds, what is the aim and benefits which the people will get, the workers will get? Life and disability cover they will get. They'll get accident insurance. They'll get health and maternity support, and some sort of old age protection and pension type benefits they will get out of this. So the idea is that a gig or platform worker should not be left with zero protection, which is as on today it's that way. Just because they work for multiple apps over a time, it's kind of regularizing them uh, almost on par as an employee unorganized sector. Let me just give an example of aggregator contribution. How, if you're an aggregator, and how you need to ensure that contribution works. So what the code says is, uh, say a food delivery aggregator is there. Okay, let me not name them, but the food delivery aggregator is there, and his annual turnover is 200 crores. Okay, and total payout to all his delivery partners. Okay, it's 60 crores. Now, the code allows the government to fix contribution between 1 and 2% of turnover with an overall cap of 2% of the amount to gig platform workers. So, if the rate is notified, say, for example, as 1% of turnover, okay, so 1% of turnover of 200 crores is say 2 crore, and the cap is 2% of the worker payout or the payout to the partner, delivery partners. So it's 1.2 crores in my given example. So the lower of the two is what the statutory contribution the aggregator has to pay. So the this is where the whole scheme is all about, and the contribution by the aggregator to the fund which will be done. So that goes to one social security fund, and for that benefit of the registered workers, and from that fund, all the benefit workers will be benefited. That's what it is. But our criteria is that the worker also gets registered under that particular platform. The schemes and things how to do about it is still not framed. It's still not come up. But eventually, next 3 to 4 months or maybe 6 months, it may just come up. But the framework is already in place and it's live active. So tomorrow, in fact, if anything happens to the employee or anything happens to the gig worker, especially accident, something, they would be covered under this provision of the new code. So let me explain why the cap mechanism matters. That's very important. When do they say 1 to 2% of turnover and capped at 2% of payouts? Because some business models differ, right? In some cases, turnover looks huge, but the actual payout to workers are a smaller size. In some other model, payout is very large. For example, what if the turnover is 100 crores? 1% of turnover is just 1 crore, whereas the payout is 60 crores. So in this, lower of the two would be 1 crore, not 1.2 crores. So somewhat similar to that. So cap ensures two things, by the way. Worker gets a meaningful contribution to a social security, and aggregators has a predictable and reasonable upper limit. So it does not turn into unviable extra tax and gross revenue. So that's very important. So for planning purpose, especially the aggregator companies, they can treat this one more statutory cost line of item, just like PF and ESI you do for a normal organized sector, or they may be doing for the normal employee in their offices who manage the whole platform or the aggregator platform or the software technician, whoever is doing the support of that. So that's very important. Let's see the rights and challenges actually for the platform workers. Can you go to the next slide, please? So for gig and platform workers, this code is the first time they get a proper seat at the table. It's very clear, right? They never were recognized all this while. So on the positive side, a statutory recognition is there for gig and platform workers. It's very good. A dedicated social security fund is available for them. A legal obligation on aggregators, especially to contribute is there, apart from government having their own schemes and all. And the promise of life, accident, health, and old age schemes is there. So that's very important. Challenge on the other side is that a lot of depends how the schemes are actually designed. We'll have to see in next 2 3 months how it is actually issued and things to really protect the rights and interests of the gig and platform workers. It's in huge numbers now in India. How easy it is for the workers to get registered and track benefits. Is it going to be done through PAF, through ESSC? We do not know about that. And how strongly this contribution will be enforced and regulated. So here you can say the door is finally open for the gig workers. The quality of the room inside will depend on the next few months, few years of policy and implementation. That's I just want to last clarify on the platform and gig workers here. So let's see. The next one is about BOCW, CES, and construction workers here under CR Code on Social Security. So Sadaf has already clarified that construction workers sit at the junction of one is OSH code and another is Social Security code. So your old BOCW, that Building and the Construction Regulation of Employee and Condition of Service Act, that's very important, which deals practically with working hours, safety, welfare on construction sites and all. That get largely absorbed into OSH code. And that I will cover in my next part 3 whenever we announce it, maybe next week itself. So that's what the old BOCW that gets covered under OSH code. In the BOCW Welfare Cess Act, which levies a cess on construction costs, typically 1% of the construction cost to welfare boards, that is placed in this Social Security code. So you understand there are these two schemes which are there, two acts, and one is under OSH code and another, the welfare part is under Social Security code, which is covered. So OSH will handle how the work is done on the site, safety, working conditions, and amenities, whereas Code and Social Security will handle how money is collected and benefits are funded through cess welfare boards. That's the whole gist of this particular BSW. So one important nuance from one of the past case law, which I remember, when a greenfield power plant is being constructed before a factory license is in place, okay, BOCW and cess will clearly apply. However, once a factory is fully licensed and operating and you are doing only internal building work with the existing factory setup or just in the precincts or premise of the factory, which your plan is approved, and you build a new building or new unit there, the BOCW will not be applicable to that. And there are many case laws also supporting the particular provisions of that. Just wanted to share this particular knowledge information on part of that. So wherever factory is active, then BOCW will be applicable. Otherwise, it's applicable to everyone. Okay. So large organizations always ask that pre-factory construction project is there or is internal expansion from within the same factory. So then the combination of that OSH part and the BCW cess will differ accordingly. That's where it is. Okay. So can we go to the next slide? So this remains largely same from employer point of view. Says compliance cycle has a very few steps, which are these 5 steps here. First, register an establishment. I don't know whether you guys doing it, but if you're not doing it, you need to do this. Register establishment on the project under the BOCW framework, wherever applicable, and calculate cess on cost of construction at the notified rate. Now, sometimes the cess which is there right now, it's 1% or something. Either the contractor pays or the overall the principal employer, the overall the person who's developing the whole unit, he pays. And sometimes in estimated cost, sometimes in audited figures. It all depends on that calculation of construction costs as such. And then file returns giving project details, cost, and cess calculation, whatever happens. And then you need to pay the cess to the welfare board within the timelines or the prescribed timelines are there as per the act. And now as per the Code on Social Security. You need to also ensure that you maintain those records like contractors, bills, muster roll, wage register, proof of payment of cess, which you've done, on what basis you collected the cess, all those things. And then whichever the beneficiaries are there, which are covered under the, the workers who are covered under BOCW, those registrations also you need to maintain the records wherever needed. So most disputes are in this area. This does not come that the law is unclear, but because documentation for cost and your work is weak, and that is where the dispute comes between the authorities and the company which are there. So clean paperwork with contractors and project teams is very important, which makes us a lot easier to manage, and that's what we have faced in many of our clients and companies which we advice and overall when we advise overall to all the organizations. Let's look at some of the records data under Code on Social Security. Next slide, please. So across Social Security Code, the code is clearly pushing towards better data and more structured inspections. It's very critical, and also web-based inspection, which I've clarified earlier in the wage code as well. So employers are expected to what? Maintain updated registers of employees, permanent fixed time, contract, apprentices, etc. And as per the new rules, as maybe framed later on, right? You need to ensure that you maintain registers. You may have to maintain two sets of registers up to 21st November on the old formats and after 21st November, the new formats. That's very important, but you need to maintain those. Maintain wage and attendance records aligned with the new wage definition. Keep PF, ESI, and other contribution records and challan safely. Very important. Download and keep it. As an auditor, I would always advise that for all my clients on this. Keep accident and occupational disease registers separately. It's very important to keep those registers also separately. And lastly, as I already told, keep construction assess records with all the calculations and all safely wherever BSCW applies. So that's very important. So inspections are intended to be done through a inspector come facilitator model, which I specified earlier as more of like a web-based selection. This means your data will be looked at algorithmically and are more at a technical eye, because it's in soft copy. So if your data is clean and centralized, an inspection becomes a discussion. If it is scattered across hundreds of Excel sheets and all, or WhatsApp groups, then it will become a headache. So you need to get all your records in a single unified tool, and that's how we'll upload things. Let's look at some of the limits in record keeping. What are they saying? So how far back the authorities can go and how long you need to keep the records. So under the old regime, if you see, PF was practically open-ended. 10 years, 15 years, 20 years, they can go back and they can really or tell you or pick you up that, okay, 20, 15 years back, you were not covered under PF and you need to cover so. So there were no clear statutory outer limit for starting an inquiry. You may be knowing or you may have experience in many cases. Authorized try to go very far back, subject to only general principles and reasonableness. They say, okay, then give me 10 years back. So for law like minimum wages, payment of wages act, other labor acts, which 3 years was usually the outer limit for employee claims and everything. And employee claims also earlier, it was 6 months rule, to maximum 1 year, but now everything is up to 3 years. So up to 3 years, the employee can claim if he gets less minimum wages, less bonus, etc. and all. So the Social Security framework talks about a 5 year type horizon for many money due matters actually. But remember one thing, PF is still running an old EPF and NPX schemes. So PF chapter until the PF chapter is notified, PF will continue its unlimited. There is no time bar as such, unlimited. They can go. However, a PF chapter when it is codified or notified, they'll also follow this 5 years, time bar. So as of today, you very clearly know about PF, but for all other code-based money claims, expect more time-bound approach around 5 years once the provisions are completely switched on. So you may have to maintain the records for 5 years or so. Income tax and everything, the way it is, if you have to maintain similar records on income tax, that's a separate thing. But what I'm trying to tell you more about the benefits and register the records as per this code on social security remains big picture is 5 years. So I would really advise you to keep full social security records, at least in 6 to 7 years in a digital form, and 5 years minimum for the legal comfort and all. That's very important. PF is exclusion, and that you need to maybe maintain for 10 years as well. So longer retention window is safer, but today longer retention also means that you need to really maintain so many physical and soft line record. So around 5 to 10 years, which you order, I would really recommend in this case. So let's see some of the transition and mixed period cases actually now. Almost every real case which straddle both sides of the code commencement date. I'd earlier given the example of gratuity, right? The employee may have, say, 8 years of service under the old acts and 2 years under the code. What happens to that? A construction project may have started before 21st November and ended after. What happens to that? Uncompensation claim may relate to an accident that happened before, but the claim is decided after. What happens to that? What are the basis of the claim which is decided after? So the golden rule is, according to us, periods before commencement are governed by the old acts, protected through saving scheme. As simple as that. Periods after commencement, okay, that is after 21st November 2025, are governed by the code chapters and schemes. Employees should not get less than what they should have get if the old law had continued. And that's important and golden. Here, the code on wages or code on social security ensure that the employee gets benefits. So if in the new code, when you do calculation and you find out, oh, employee is getting lesser than the old code, it's better to give, higher than what both the things are there. If you do not give, the whole spirit of law seems to be, you can say, not good at all under the spirit of law. So something like gratuity for a mixed period case here, you take so total service, apply the code of wage definition, and always sense check that the old act formula and to not ensure the employee is not worse of all less. That's what I would try to suggest in this transition mixed period cases, especially all across the code on social security, including PFES, all those cases, which I would say. So let's look at what are the employer action points which you need to take under the code on social security. Very, very critical. What do we do from Monday onwards, or the Monday part, which I can say, or what do we do from tomorrow onwards? So first bucket is to cover and the coverage and wages is the first bucket which we need to see. Map whoever is in your organization. That's very, very important, which is covered in the PF, ESA, gratuity, maternity, then or your employer compensation, BOCW. If you are part of, if you're an aggregator, then part of a gig and platform, you need to just map all those. Then secondly, you identify which employees are fixed term, which employee, whether 1 year gratuity would exposure will exist, and also you need to map those. You need to just identify which kind of FTC and FTE you may have, right? Then build a code plus 50% rule, which we always told you that code wage, which is then plus 50% rule in your payroll engine for ESSC, gratuity, maternity, all those aspects. Right now, keeping PF wages is a separate line based on current PF law. PF in ESI, you can keep it a separate line, but start doing this in your payroll policies, which is there. So this is really required, in fact, as a data and exercise with the legal inputs, just not legal exercise. So this kind of approach, if you have, you are more or less 100% compliant on code on social security, which I would say. The second bucket, if you see, is for the contracts and processes. Can you just go on the next slide? Oh, no, the previous slide, sorry. Second bucket, if you see, yeah, uh, you need to update the appointment letters. You need to ensure that fixed term contracts are there. You need to ensure that HR policies reflect the new definition, which is very, very important. um, Especially the gig and platform workers, which you need to include that. If you're an aggregator and you need to provide those information, then you need to include in your HR policies, the definition of gig and platform workers according to you, and what are the benefits you're going to be with. You need to also check contracts with contractors and aggregators to ensure social security is done. If you're outsourcing that, the whole social security, and you're an aggregator and you're outsourcing the whole activity to a contractor, ensure that they are covered and you govern those coverage and all as the time to time the scheme is announced and it comes up. Ensure that you strengthen your accident reporting and investigation process. That's very important. If you're already doing it, it's very good. If not, then you need to ensure that, because this will feed both the information under PF Act, under ESIC Act and under Employer Compensation Act. So you need to ensure that you record everything under that. And for some of the companies who are construction heavy businesses, set up a clear internal owner for BOCW registration, CES, liaison, and with welfare board. So because both the acts are different, if you go to see overall the BOCW Act, one aligns with the OSH code, and on the welfare part aligns with the code of social security. So unless we translate the whole code into letters, policies, SOPs, and everything, it just remains theory. So while government will do its bit about aligning, about giving clarification, about ensuring that the schemes are really aligned with the codes, all the four codes, you as an organization also need to set up and step up to ensure your policies and framework around this codes are aligned. That's what I would say. So let's see, summarize the whole classic pillars of ours. So first of all, Social Security Code considered 9 laws into one architecture, but PF Act continues for now, and PF wages will still follow PF specific rules. Okay, so ideally only 8 acts are replaced as on 21st November 2025, which we are keeping on reiterating that. The saving clause is your bridge, like a bridge. Existing schemes, rights and cases carry through, and they are not wiped out, and then you have a new code altogether. So that's what it is. The saving schemes is very important for you to again read through. If you're already providing the FAQs on that, you can read through that as well. Single definition wages, which we are reiterating, plus the 50% cap on exclusions, is a central engine for most of the social security calculations. ESS is moved under the code umbrella, while with family and dependent already widened, the wage alignment expected through the future notification whenever the government will issue. Till that time, you continue PF in ESA as it is. But gratuity, maternity, employer compensation are clearly inside the code. And the fixed term employees under the gratuity is also 1 year path of gratuity is already there. So for this gratuity, maternity, employer compensation will be clearly as per the way code definition of wages. That's very important. So I hope you align with this. Some more. Let's look into more about the on the unorganized sector. So here, unorganized workers are moving towards a single national register model, which I already spoke. Something like we have e-Shram model, which will come, which will link to very multiple schemes and benefits which the unorganized sector will happen. The gig and platform workers, which I already clarified, will get a dedicated social security fund with aggregators contributing based on their turnover or the payouts, which I already clarified with the good example. The construction workers under BOCW, for example, their conditions are moving to a OSH code, whereas the welfare is moving to the Social Security code. So we just clarified that as well. And inspectors are expected to be more data driven and risk based. And a limitation of many code money claim will be around 5 years mark. Uh, Hopefully, PF also comes very sooner in this 5 years, and people are not still thinking about 10 years, 12 years. Mind you, one thing that the existing maybe the inquiry which are like 8 and 10 years old, even the PF comes with the new rule very soon, as say maybe tomorrow or next 1 month. The existing things will still continue until it is closed. So newer definition, newer inquiry, say under section 7A and something there, they will be having maybe having a 5 year cap. But we have to wait till the government announces that. So that's very good. So overall message is that Social Security is no longer just a PF and ESF for factory workers. It's an integrated ecosystem. Okay, covering formal employees, unorganized workers, gig workers, platform workers, construction workers with much more higher expectations around data and systems and the benefits, and ensuring the benefits to each one of these people reach. So that's what I just wanted to share as things, and I hope I was good enough to tell you. So this is very so planning your social security map easily. You need to ensure this about your immediate actions, your midterm steps. Ensure gratuity funding arrangements are very clear. You know the midterm step because the gratuity funding will increase because they will be part of the new wage definition for the gratuity purposes. You need to ensure that is very clearly. And also you need to include those fixed term contract guys as well, if that is not included in your gratuity fund. So that's very important. Long term, along with Karma, of course, we will monitor scheme notification and rule changes, but you need to ensure that you integrate this cost compliance, that is code and social security compliance in your HR policies and part of broader HR strategy. That's very, very important to have that. So thank you for staying with me right till the end of this deep dive into the code. And I know PFESA gratuity says and all these definitions are not exciting as salary hikes or bonuses, but when something goes wrong in an employee's life, it's exactly what families afloat. We'll keep updating our materials, and as more notification and scheme level details come out, you do write in any information you have or if any query you have to this particular email ID laborcoach at karmamgmd.com. Very, very important. Uh, if your specific cases like mixed periods or complex salary structures or gig up platform models or something on the construction projects, feel free to reach out my team and we'll be happy to look at those individually. For now, thank you once again for your time and attention, and I'm happy to take questions. Easy ones first, tough ones immediately after, and some of the questions which are not answered, let me take you through. Um, Remember, right now the 118. We will keep in next 20-25 minutes. We will keep it open. It's up to you to ask questions, and we will take the question on the chat and then we will wind up on next 20-25 minutes. So I hope this is where we are today. I would want you to give me immediate feedback as well. It must be popped out in your screen. I would really urge you to give me feedback so that we are prepared for the next uh, session. So over to you, Dhanasvi. In fact, you want to just announce the next session, please.
Thank you, sir. We truly appreciate your time and engagement in part two of a three-part series from chaos to code. We hope today's session on the code on Social Security 2020 has provided meaningful insights into the evolving landscape of India's labor framework. A special thanks to Mr. Prateek for sharing his valuable expertise. The FAQs document and today's presentation have been uploaded on our website. Please feel free to explore and make the most of these resources. We will look forward to having you with us in our next and final session on Friday, the 12th December, on part 3, the Industrial Relations Code, and the Occupation Safety Health Code, where we will conclude our discussion on the complexities of India's labor reforms. The registration link will also be shared shortly. So have a wonderful day ahead, everyone.